just a little bit of a recap from what we saw out of the Department of Labor in the first year of the Trump 2.0 administration here. During the first year of the new administration, the Department of Labor really focused more on departing from Biden and Obama era work rules rather than introducing new ones. So that really kind of means that it was sort of rescinding guidance that you saw under Obama and under Biden. In March, Trump rescinded Biden's 2021 executive order that led to a final rule that increased the minimum wage for federal contractors to $15 per hour. So he rescinded that one almost right away in May. The Department of Labor said it was going to stop enforcing the highly contested Biden era final independent contractor rule, which rolled out a six-prong economic realities test to determine whether workers are independent contractors or employees. That rule had faced several challenges, and some of those challenges are still pending. Earlier this month, the Department of Labor told the Fifth Circuit that it was revisiting the rule, raising the salary threshold to consider employees overtime exempt under the Fair Labor Standards Act. And so what we really have seen is that a lot of these regulatory moves are related to issues that have been going on for quite some period of time, but we're seeing a shift in the direction of the government regarding those rules. And so I think we're likely to continue to see that. In July, the Department of Labor introduced a rule that revisited an Obama-era regulation that involved home care workers. That proposed rule would reconsider and stop enforcing a prohibition on third-party agencies from claiming minimum wage and overtime exemptions under the FLSA for some of those workers. So that was a rule that had gone into effect in 2015. And so, again, the Trump administration is looking to sort of peel that one back as well. So, and I think, we've talked about it so extensively on the program that it's worth noting that in light of the U.S. Supreme Court's nixing of the Chevron deference standard that we've talked about ad nauseum here, that really does breathe new life into the debate over some of these Obama rules that people thought were set in stone, where the courts were basically told to defer to the Department of Labor and the expertise of the Department of Labor. And I think that you're seeing some people emboldened to challenge some of these things that, again, seemed previously set in stone. So I think we're likely to see the Trump administration continue to sort of go back to the way things were pre-Biden, pre-Obama with respect to the Department of Labor.
Yeah. And like we always say on the show, it'd be great if we can just get to that space and then balance out for a period of time and let our employers, gain some momentum and build their workforces, around some stability instead of this pancake flip-flopping, one party, another party, and we don't really know which way to go, and we're trying our best as we go along.
Yeah, that pendulum that we talk about,
Yes.
that swings wildly from one administration to another, and I've said it before, we don't necessarily mean it literally, pretty close to literally, but not literally. We just want to know what the law is, and we want to have them have it stop changing every 4 to 8 years, so that what's legal under one administration doesn't become illegal under another administration.